Okay. In this divorceresource.com blog, we will be talking about how to reach a marital settlement agreement. There are several ways for parties facing divorce and separation to reach a marital settlement agreement. The traditional way for a party to enter into a settlement agreement is to have his or her lawyer draft the agreement and present it to the spouse. This is called a settlement proposal. The spouse who receives the settlement proposal will then review it with his or her lawyer and will advise the spouse of any changes desired in the agreement. This is called a counterproposal. The process of going back and forth with proposals and counterproposals until a settlement is reached is called negotiation. An experienced family lawyer can be very effective at negotiating a settlement on behalf of his or her client. There are certain rules for ensuring that you successfully reach an agreement. Generally, negotiation requires compromise on both sides in order to reach an agreement. You must be prepared to give in with regard to your position. Number two, it generally takes reasonable people to reach a settlement. If you don't have two reasonable people, and one of them is being arbitrary and unreasonable, it is extremely unlikely that you're going to be successful in reaching a settlement. When a party makes a settlement proposal, it should not be a wish list of everything he or she wants. There must be some consideration given to what the other side is likely to agree to, or else you're going through a very wasteful exercise. Parties need to be realistic and reasonable if they want to reach a settlement with their spouse. The most popular alternative to this traditional approach of negotiation is what we call mediation. What is mediation? Mediation involves a third-party neutral facilitator called a mediator, whose job is to sit down with the parties and facilitate or help their working through their issues and reaching a settlement agreement. The parties will determine what issues need to be addressed and how each issue is ultimately resolved. Who are these mediators? Mediators can be anyone trained to be a mediator. They don't have to be a lawyer, and they don't even have to have a college education. So you need to be very careful when selecting who your mediator will be. The most effective mediators are experienced family law attorneys. These mediation-trained lawyers know family law and can be a tremendous resource for both parties as they work their way through the mediation process. What are the benefits of mediation? The first and the most important benefit is that the parties are in control of the process, not the lawyers. The parties are directly face-to-face dealing with the other side and communicating their views and positions to the other side. So nothing is going to be lost in this process. Another advantage is that as opposed to the traditional approach where each party has a lawyer, in mediation you are only paying one professional, the mediator, not two. So it is less expensive to go generally through mediation. Thirdly, both parties have access to legal information from a family lawyer. And this would be an improvement over a situation where one of the spouses goes and gets a lawyer and has the agreement drawn up, and the other spouse does not have a lawyer. If they both participate in mediation, they're both part of the process, and they both have access to an experienced family lawyer who can provide them with legal information. What are the disadvantages of mediation? One of the biggest disadvantages of mediation is that neither party has an advocate to fight for them concerning their respective positions and the issues in their case. Remember, a mediator is a neutral facilitator, and he cannot take the position of either side and stay in the role of mediator. Secondly, a mediator cannot give legal advice. A mediator cannot tell either party what he or she should do or what they should decide on a given issue. A mediator can only provide legal information that will allow the participant to make his or her own decision as the mediation process proceeds. Is mediation for everyone? Unfortunately, it is not for everyone. It's not recommended, number one, where there has been a history of domestic violence between the parties. Number two, when one party has a serious drug or alcohol abuse problem, we don't recommend mediation. And number three, when one of the parties has a mental health issue that could impact on the mediation process. I personally also discourage mediation where one party has an inability to speak up for his or her own rights and positions, or where one party feels intimidated by the other party. Please visit Divorce Resource's website, divorceresource.com, and view our other blogs. We appreciate your taking an interest in Divorce Resource, and we hope to see you back soon. Thank you very much. Have a good night.